Hello, this is Matt on the Moon Lambeau channel. Today, attorney John Deaton filed a letter to Judge TORRES in the SEC versus Ripple case, and it is jam-packed full of information. Buckle up for this one. There is a lot to cover here, but you're going to absolutely love it. And one of the things that attorney John Deaton does address is the SEC's completely absurd and offensive position that attorney John Deaton should no longer be allowed to participate in the case in any capacity. In fact, in June, SEC attorneys, being the little assets that they are, they actually wrote to Judge TORRES and said that attorney John Deaton should be barred from any future participation, and they articulate their reasons why. Now, I already made a video pushing back on that nonsense, but you're going to get to hear from attorney John Deaton himself why that is completely BS in his own words. And there's a whole lot of additional stuff in here having to do with Daubert challenges. So, you know, the Daubert challenge would be an assertion against an expert witness regarding whether or not they're actually an expert and should be allowed to participate in the case in any capacity, or there can be an assertion that there's flawed methodology surrounding assertions made by an expert witness. There's a ton in here. But before going any further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So the latest filing, it's 5 pages, not including all the additional exhibits. One of those 5 pages is just a signature line. But given that it's not insanely long, it's amazing how much incredibly detailed information is included in here. In fact, before we get going, I wanted to share with you attorney Jeremy Hogan's response to this whole thing. He simply wrote the following. And again, it's from attorney Hogan. He says, attorney Deaton's response might be my favorite brief in the Ripple case so far. It defends his position in the case, defends his own actions, attacks the SEC, attacks the SEC expert, all in 4 pages, and also happens to spill on Hinman and his relation to Ethereum. Bravo. And he's not kidding. Like, this is an absolute masterpiece, which I'm saying just basically like, kick back, put your feet up on the desk, relax. You can pause here, get some poppy corn if you want to do that, pop some popcorn. It's a good time here. And as far as this part having to do with Bill Hinman and Ethereum, I'm going to save that for the later part of the video because that's where it's going to fall in terms of where that's mentioned in this document written by attorney Deaton. So what I did is, you may hear this, got some dead trees up in my hands, son, so I printed this bad boy up. I highlighted it, the parts that I knew I wanted to cover as I went through reading this, and it's almost 100% of it. Almost exactly 100% of it. I also took some notes along the way because I didn't want to forget certain things. So let's go ahead and just jump right in. And, actually, I'll share this first because attorney John Deaton, he shared this document, and I'll try and remember to scroll through as I'm sharing the specifics, because I'm going to be looking at my paper rather than the screen most of the time as I'm recording this. But attorney John Deaton, upon sharing this document, he shared a snippet which presumably would be one of his favorites, if not his most favorite, since there's limited characters on Twitter here. But he shared a snippet from his legal brief that he filed to Judge TORRES today, which reads as follows. If this court were to adopt the SEC's theory regarding XRP, it would dramatically change the regulatory landscape for the entire cryptocurrency industry, end quote. And you'll see as we go through this, Judge TORRES is definitely sufficiently informed, or at least has been sufficiently to this point, regarding the position of XRP holders in general. Now, there's a lot more information that does need to be conveyed, but John Deaton is doing a fantastic job on behalf of XRP holders just in general. And so here's the actual document filed today, which reads as follows. Dear Judge TORRES, unprecedented is a gross understatement when describing this case. Because of the SEC's sweeping allegations that XRP itself is a security, almost immediately this case was dubbed the cryptocurrency trial of the century. See SEC v. Ripple, the cryptocurrency trial of the century. So I'll just pause and note, and then there is a link in there which goes to the Forbes article with that title, and I've covered that on the channel before. And it's not too much to state that it's the cryptocurrency trial of the century. That's what it is. That's how much is at stake here. This is gigantic. There's a reason that Fox Business regularly now is having attorney John Deaton on. And then it reads as follows. The case represents a significant regulatory overreach. If this court were to adopt the SEC's theory regarding XRP, it would dramatically change the regulatory landscape for the entire cryptocurrency industry. And then it says, there's a little heading here, the SEC's unlawful expansion of Howey. The token represents a security per se. So I was pausing. This is something that I've been harping on for the longest time, and I'm certainly not the only one. But it bothers me to no end the degree to which the SEC's just engaging in a tremendous power grab. And even though they don't have any sort of legal precedent to make it reasonable for them or legal for them to do what they're doing, they're just doing it anyway and seeing how much they can get away with. I am disgusted by these people. And so Attorney Deaton wrote the following. Although the SEC laments Amici's presence in this case, and I'll just pause and of course, I think everybody knows this, but I want to make sure we're all speaking the same language. Amici, when Amici is referenced here, we're talking about those 68,000 plus XRP holders who are represented by Attorney Deaton. So anyway, although the SEC laments Amici's presence in this case, the SEC itself is to blame because of its unprecedented allegations. Indeed, the SEC's XRP is a security per se theory has been at issue from the very beginning of this case. As the defense correctly pointed out, and this is a quote here now, so this is coming from Ripple's team, reads as follows. The SEC included in its complaint conclusory allegations suggesting XRP is always a security, and therefore that every offer, sale, or transaction involving XRP is subject to the panoply of regulatory requirements mandated by the federal securities laws, end quote. And then John continues, excuse me, sorry. During the very first substantive hearing, Judge Netburn questioned the SEC's implausible theory that, quote, every individual in the world who is selling XRP is committing a Section 5 violation, end quote. Now, the defendant's cogent recitation of the SEC's response to Judge Netburn encapsulates the underlying issue. So I'll pause here. What I'm about to read is verbatim. It's in John's document, so it's what's on your screen, but it's from the defense, so we're talking about Ripple's legal team here. This is what they're asserting. And I'm going to read it as it's on the screen, and then I'm going to spit back what it actually, just to make sure that we're on the same page. I'm going to try and use, more like everyday human speak rather than lawyer speak, just to make sure that we're all on the same page. But it reads as follows. The SEC did not dispute the premise of Judge Netburn's question, responding ambiguously that non-parties XRP transactions would likely be exempt under Section 4, which only applies to a security subject to registration under Section 5. The SEC essentially confirmed that regardless of the seller or circumstances of the sale, XRP is in its view per se an investment contract and therefore a security per se. Now, that premise, if accepted, would empower the SEC to regulate vast numbers of non-parties, including digital asset exchanges, vendors, and retail holders. This directly threatens the interests of Amici, even though there is nothing about their conduct that could plausibly make XRP an investment contract and thus a security in the context of this litigation. End quote. Okay, so what's being stated here is that retail holders are protected under what's known as Section 4, but only if XRP is a security subject to registration under Section 5. So purely by the nature of XRP existing, right? So the SEC is arguing holders of XRP are protected, but they're protected because XRP is a security. Otherwise, Section 4 doesn't even apply. And they actually argued this at a pretrial hearing, mind you. But see, this would give the SEC power to regulate people having nothing to do with Ripple. And so that if you're protected, you listening to this, if you're protected under Section 4, well, then XRP has to be a security per se. Because again, the only way that you're protected under Section 4 is if Section 5 applies. And if Section 5 applies, that's because XRP is a security. Otherwise, none of this makes sense. So hopefully I did okay in trying to break down what that is. But it is complete and utter nonsense. Because think about this. They're arguing that they're not attacking XRP holders. Like, they've even said this recently. And they'll say that. But then they'll also argue what I just shared with you. So they're arguing out of both sides of their mouth. It's completely disingenuous. It's like they're trying to use big speak and complex ideas that nobody really understands to trick you into thinking that what they're doing actually makes sense, but the judge caught them. Anyway, Attorney Deaton continues. After that hearing, and prior to the court granting amicus status, the defendant specifically asked the SEC to clarify its theory and thus minimize Amici's involvement. The defendants unambiguously asked whether the SEC was seeking, quote, to establish XRP is an investment contract per se, or that defendant sales of XRP resulted in an investment contract based on the circumstances of those sales. Let me scroll down a little bit. We're at the top here, page 2 now. And then it continues. The SEC responded, and here's a quote from the SEC. The XRP traded, even in the secondary market, represents that investment contract, end quote. So the SEC's representation theory constitutes an unlawful expansion of Howey. Commissioner Hester Peirce agreed that SEC enforcement lawyers are precariously expanding Howey, as applied to XRP, when she publicly criticized the SEC's theory by stating, quote, what we've done now is said the orange groves are kind of like the security, so i.e. represent the security. Where the hell does that come from? You go back to because look, this went to the Supreme Court, mind you. So you go back to 1946, the Howey case. Where was this language about orange groves or oranges being representative of the security? This is a new concept. It's not within the confines of the law. It has nothing to do with legally binding precedent whatsoever. Nothing. Nothing whatsoever. They're just saying things and hoping to get away with it. Now, thankfully to this point, Judges Knepper and TORRES haven't let them get away with much. Fine, you could argue there's been certain delays, this or that. Okay, fine, whatever. But in terms of materially what's been made public and what's important, they haven't gotten away with anything of notable importance, certainly not off the top of my head anyway. There's been little things here and there, and I've been covering the case consistently. I can't think of anything gigantic where I'm like, that really is one that concerns me, in terms of how this is actually going to resolve itself ultimately. Anyway, Attorney Deaton continues. He has a section called The Expert Firestorm. This is interesting stuff. Listen up. In order to somehow prove that the XRP traded today in the secondary market, independent of Ripple, represents an investment contract with Ripple, the SEC arms itself with the opinions of a paid expert from an entity granted a multi-million-dollar government contract funded by the SEC to support its unprecedented expansion of Howey. The SEC objects to my request to file a non-duplicative amicus brief regarding this one expert. So let's pause now. Attorney John Deaton made it known that he does want to be able to respond to the perspectives here that's filed by this particular analyst in question. I believe the individual being referenced here is Patrick Duty, though he's not called by name. That SEC objects to this. And all he's saying here, and he goes into greater depth, so I'll let him mostly speak for himself here, but he did state right there, he wants to be able to file, but it's going to be, if he's allowed, it would be a non-duplicative amicus brief, meaning that it would be him representing the 68,000 plus XRP holders, it would be a legal filing, and it wouldn't be a bunch of information that's already been submitted. He's made it clear that's the intent, right? That's what he's told the judge. Anyway, Attorney Deaton continues. Let me make sure I didn't lose my spot here. I might have lost my spot. Despite I should be okay jumping in here. I apologize if I'm going over something I just read, but it'll flow. The SEC objects to my this is the spot. The SEC objects to my request to file a non-duplicative amicus brief regarding this one expert. Despite the expert providing opinions regarding Amici's state of mind when purchasing XRP, the SEC asserts Amici should not be allowed to participate because Ripple shares a common interest and the proposed brief would merely duplicate defendants' efforts. So again, the pause and note, that's why it seems pretty obvious to me. This has got to be Patrick Duty. He's the one that's been touted previously as the guy that claims to know why XRP holders have purchased XRP, yet he's admittedly, I think anyway, admitted to never having spoken with a single XRP holder. And the reason I say I think that that's the case is because we did see part of unredacted testimony. So it was an actual legal deposition, so he's under oath. And the name of who was saying this wasn't here, but if you put all the context together, that's why I think it's him. He said, and I'm paraphrasing here, but no, I did not speak with any XRP holders about why they purchased XRP. Might that be a tremendous blind spot, a tremendous oversight, or might you have not done that because you wanted to ensure that you got a particular outcome? Either way, it's not going to be looking good for him. Anyway, Attorney Deaton continues. But I made clear I would only seek leave to file a non-duplicative Daubert amicus brief. Unfortunately, my request inadvertently provoked a firestorm the SEC blames on me. However, all the recent issues related to this expert would have been avoided had the SEC agreed to share a then non-confidential report after I agreed to comply with the existing protective order. My proposal was that I would read the report and deposition testimony and, after reviewing Ripple's Daubert motion, would only seek leave if I could offer the court a non-duplicative perspective. It was entirely possible that I would review Ripple's motion and do nothing. The SEC now not only objects to Amici's participation in the Daubert challenge, but moves to punitively bar me from participating any further. And that's what I was referencing at the outset of the video. They actually, in June, filed a document, which we didn't find out until within the last few days or so existed. But we got the redacted version, of course, heavily redacted. But we found out that in June, that the pricks over at the SEC, they're actually trying to get Attorney Deaton barred from participating any further. And it's so interesting because, as I cited in a video where I covered this and just roasted the SEC for this nonsense, they made the same claims, like today, in order to try and get him barred from participation, the same claims that they made in the beginning part of 2021 when they were trying to prevent him from being allowed to participate in the case. It didn't work then, and what, they think it's going to work now? I don't think so, my friends. That doesn't sound likely at all, does it? Anyway, Attorney Deaton continues. There's a new section here which says, Ripple and SEC lawyers identified experts well before Amici's motion. And then the section reads as follows. It was impossible to foresee the issues that arose from the disclosure of the expert's name. Prior to Amici's motion identifying an expert, both Ripple and the SEC publicly discussed one of the SEC's other experts, as well as defense experts, in relation to a motion to strike an SEC supplemental expert report. Judge Knepern's decision on the issue also publicly identified experts. I never anticipated the issues with the second SEC expert, nor should I have been expected to, particularly in view of the release of the other expert's identity by the parties. As for the threats of harassment, I have publicly denounced and discouraged such activity. I have received threats myself and take them seriously. In truth, the parties and the court are aware that I have been included on threatening correspondence. In light of the above, it would be grossly unfair to single out and punish me for threats made by people over whom I have no control. Yeah, exactly. Another incredible, obvious... It's painful that John Deaton even has to point this out, but he does have to point this out. He has no control over these people. In fact, he is encouraging people to just stay calm. Certainly don't threaten anybody. I mean, and I say the same thing on my channel. I don't know what was done because that hasn't been made public, but there's some sort of threat against this expert, and for the SEC side, and I don't know what it was. So hopefully it's not something being overstated. But assuming it's completely valid, that's disgusting. You don't threat people. You do not threaten people. That is not appropriate. You don't, and you're harming the case. Because look, whoever did that, it resulted in this, John Deaton having to write about this, and now I'm making a video about it. Just don't do that. You're not helping the case. You're not helping anybody. Most certainly not. It's not right or ethical or moral. Just don't do that. Just shut your damn mouth. And if you're feeling emotions, I don't know, man. I don't know what to tell you. Just go feel them somewhere else. Not on the internet. All right. So but you're not doing yourself any good either. Aren't you worried yourself about even just getting in trouble for making actual? Are you not worried about that? You should be. Don't do that. Don't be a freaking idiot stick. Anyway, and then there's another section titled The SEC's Hypocritical Stance Regarding the Expert's Report, which reads as follows. Not surprisingly, Not surprisingly, the SEC took the opposite position regarding the same expert with the different XRP holders who share the SEC's desired goal. In an Oakland federal court, several XRP holders sued Ripple, alleging XRP sales violated securities laws. So I'll just pause to note, there are actually a few lawsuits that were started. I believe all of them, I could be mistaken, but I think all of them, prior to the SEC suing Ripple, people made minimal investments in XRP, lost some money, decided to start lawsuits, file a lawsuit against Ripple anyway, and just claiming that Ripple had sold XRP as an unregistered security. And I believe at this point that all of those lawsuits have been congealed into one. And it's not like it's a ton of people. It's a very small minority of XRP holders, substantially under 1% of humans who have ever held XRP at any point in time. It's a very minuscule group here. And it makes me wonder what their true intentions are, because it just doesn't make logical sense. But that's separate. So now there's this Oakland case. That's what's being referenced here. It's these people, these other, or I don't know if they're currently holding XRP, but at a minimum, former XRP holders who are making these assertions that Ripple did sell XRP as an unregistered security, and that's separate from the SEC versus Ripple case. So that's what the Oakland case is. Anyway, John continues. In Oakland, the judge ruled Ripple must produce all written discovery and deposition testimony produced in this case. So when he says in this case, he's talking about the SEC versus Ripple case, including all SEC expert reports. So again, everything from this case, the SEC versus Ripple case, it's got to be handed over for the Oakland case too, right? Now, the SEC did not object to these XRP holders obtaining the same information sought by Amici. So it's again, the people that John Deaton's representing. In Oakland, the XRP holders already have the identical expert report the SEC refuses to provide Amici only because the SEC is aligned with those XRP holders. The SEC's diametrically opposed legal position is consistent with Judge Knepern's harsh but accurate observation that the SEC is, quote, adopting its litigation positions to further its desired goal and not out of a faithful allegiance to the law, end quote. And so you might well remember that was the harsh language, and I love that. That was like my favorite. Well, it's from part of a paragraph, and that was my favorite in the write-up on that, and that was on the SEC's bogus attorney-client privilege claims, which Judge Knepern was having none of that. It just didn't make sense. She went so far as to say that they were being hypocrites, and that she didn't think that they were being faithful in terms of their allegiance to the law. They were just asserting things to get to their desired goal. That's what that quote was from. So that's very recent, and so this makes the SEC hypocrites. What they're doing here. Because, look, allow XRP holders in the Oakland case to have the expert report, since the XRP holders in that case agree with the SEC, but don't allow XRP holders in the SEC versus Ripple case to have the same report, since they know it would be used as ammo against them. That's hypocritical. The SEC is literally arguing, here's the set of documents. You, in the Oakland case, get them because you're on our side. You, in the SEC versus Ripple case, don't get them because you're not on our side. It could not be more obvious that what they're doing is disingenuous. That's why it was so brilliant of John Deaton to whip out that quote from Judge Knepern's latest huge legal ruling. It's pure fire. John Deaton just spitting fire here, page after page after page. Then there's another section here titled "A common interest doesn't negate Amici's role." Reads as follows. In determining whether to reject the SEC's request to bar Amici, the court should consider that, in a sworn interrogatory, Ripple unambiguously stated it, quote, does not have knowledge of all current and potential uses and functions of XRP, and such information is outside of Ripple's possession, custody, or control, end quote. And by the way, that's another thing where I'm just looking at, it's an obviously true statement. So that proves not only that their interests are not aligned, but also, it's not like they're issuing a stock and then they're aware of like who's buying and selling it. This is an asset, a thing that has utility that can be used, and as such, not only can Ripple not control it, there's no way that they could possibly know literally everything that it's being used for. And not that technically anybody could, not even John Deaton representing Amici, but our interests are different, and we are much more aware than what Ripple is doing in terms of additional development for the XRP ledger. Because Ripple doesn't care. They're a business trying to create the internet of value, right? That's a totally different thing. It's not their job to be aware of all of this stuff. But Attorney John Deaton is, and the broader XRP community sure as hell is. I've been talking about it on this channel for years on end. The information is out there, but it's not Ripple. We shouldn't expect, and Ripple is not, staying on top of all of that. We shouldn't expect them to, and they're not. Fine. I don't care. It doesn't matter. Anyway, Attorney Deaton then continues. Oh, did I just lose my spot? No, I didn't. Wait, did I? Yeah, oh no, I'm good. Okay. Reads as follows. The SEC had asked Ripple to list all known use cases for XRP, and Ripple responded in part by referring the SEC to a letter motion put forward by me. Even assuming a common interest, it does not negate Amici's role, considering this court acknowledged, quote, Amici may view XRP differently from defendants and thus may stress different arguments, end quote. So look, that's from the court. Let me just pause and note, that's from the court. The court saying that Amici, so again, that's all those being represented by Deaton, might view things a little bit differently than Ripple. Well, that's obviously true. Of course that's true. Attorney Deaton continues, and he says, the specific Dalbert issue here involves Amici's acquisition and use of XRP acquired in the secondary market independent of Ripple. It follows that Amici may offer a distinct perspective and stress different arguments. Next section, titled Amici complied with this court's order. The SEC attempts to cast Amici in an unfavorable light, suggesting Amici is attempting to avoid this court's order, disallowing Amici to present evidence. I delivered to the parties, not the court, affidavits signed by XRP holders from the United States and abroad. I provided information demonstrating the validity and methodology of their creation and collection. Considering Ripple affirmed that it lacked knowledge of all current and potential uses of XRP and that such information was outside of Ripple's possession, it made sense to provide the information. So I'll pause and note there, in terms of the claims that John Deaton did something wrong or broke rules, no, he didn't present this evidence to the court. Again, as he cited here, he sent it to Ripple and to the SEC, well within his rights to do so. So the SEC is just lying by making assertions that he somehow broke rules of the court. But that's the kind of trash people that we're dealing with here. Attorney Deaton then continues. He says, I delivered the documents to the parties in an effort to offer the foundational basis of Amici's perspective for potential participation in the briefing of legal issues. The SEC is upset because I stated that I hoped Ripple would choose to utilize the affidavits, but I made no demands or threats of any kind. I hoped the affidavits would be helpful to a party that swore under oath it lacked full knowledge. Think about this. If he's handing this information over, don't you think that, of course, he would hope that it would be useful for the parties that are receiving it? Isn't it then reasonable for him to state, I do hope that this is useful? Of course, that's reasonable. Of course, that's reasonable. Attorney Deaton continues. All I and Amici can do is hope, because the reality is the parties are free to use or reject the affidavits as they see fit, and I and Amici can do nothing about it. In essence, the SEC criticizes me for complying with this court's order. Defendants have the opportunity and motive to acquire the evidence Amici would offer. That's exactly, and that's in quotes right there. Candidly, I could have forwarded the affidavits to only Ripple to be utilized pursuant to Rule 56, but instead forwarded them to both sides for transparency. Exactly, which seems perfectly reasonable because he's not afraid of the facts. Give them to both sides, exactly. He just wants what's right to be done here, obviously. And as far as the affidavits, of course, I've not seen them. That won't shock anybody, but there are, my understanding anyway, and I don't want to misspeak, so I'm going to share with you that this is my understanding, and if I'm making a mistake here, somebody just let me know if you know. But my understanding is that there are over 3,000 XRP holders who have testified. My understanding is, I think it's sworn testimony anyway, that they cite the reasons that they purchased XRP, and there could be other stuff in there, obviously. So again, I've not seen this, but John Deaton has publicly stated he's got evidence that I think he said like over half of people that first purchased XRP, they hadn't even heard of Ripple at that time. Well, can you imagine if that's the case if like you're buying a stock? Like, I don't think you'd have the same. Unless you're buying an index fund, but then you're buying the index fund, right? That's a little bit different. But if you're buying individually, it's like, I don't know, that's well, fine. Maybe you get some of those people that don't know what they're doing. They're buying random stocks, but you think over half of them? It's completely absurd. It's just offensive to like how stupid do you think we actually are? Come on, SEC, you little freaking asshats. All right, and then there's so we're at section 5 now, I think, right? Yeah, here we are. So section 5, right here in the middle of your screen currently. Getting towards the bottom of page 3. Since the SEC cannot attack Amici's message, it attacks Amici's messenger. For the second time, and I was just pausing, I want to say something before we even get in. This part really grinds my gears. So it's the same thing that happened, and you'll see, I'm mostly just going to let John speak for himself here, but it was so offensive when they went on this character assassination rampage last year in a desperate attempt to get the judge to not allow John Deaton any sort of participation in the case. And this is the part where, and you'll see John Deaton speak for himself here, they're doing the same thing again. It already failed, but they're trying it again. You think you're going to get a different result? Probably not. I'd be surprised. Anyway, reads as follows. For the second time, the SEC engages in character assassination, asking the court to revoke Amici's status and bar me from further participation in this matter. It is not a coincidence that the SEC makes this radical request on the eve of summary judgment filings. The proceedings this court signaled as the most relevant and desirable for Amici's participation. Let me scroll down. We're somewhere on page 4 now. The SEC recycles materials it previously provided to this court when it argued against granting Amici status. So let's pause and note. Folks, this is literally what I was arguing however long, when was it that we found this out? That's within the last several days or so. I can't remember exactly. But as soon as we found out, I was just like beside myself. You should have seen me when I was reading this alone by myself. I was like, are you freaking kidding me? Trying to bar Deaton? Like, I couldn't believe what I was reading here. It was just so nonsense. It's just such garbage. And I was sitting there and I said it in a video too. I already said it publicly before this even filed. I was like, this is the same thing that they argued back then. Like they're even citing the same tweets and stuff and videos from the beginning part of 2021 in 2022. It's insane. Anyway, Attorney Deaton continues. This information was known to the court when it granted Amici status, but granted it anyway. This issue was fully addressed in Amici's reply memorandum to the motion to intervene. It deserves no further comment. While I cannot control people on social media, I've made every effort to promote and respect the judicial process. Considering the public outcry related to this case, my presence has likely minimized disruptions from the public. I have cautioned against recording court proceedings, to never contact the court, witnesses, the parties, or their attorneys, and cautioned against calling into hearings before the scheduled time. Nothing, quote, presented by the SEC warrants a reversal of this court's decision to allow Amici's participation, end quote. In truth, the SEC's personal attack is retaliation over my efforts demanding an investigation into the massive conflicts of interest related to the June 14th, 2018 Hinman speech declaring Ether a non-security. That speech has been the main focus of litigation throughout this case, and it continues to dominate the proceedings. My efforts with others led an independent nonprofit watch group, Empower Oversight, to request a referral to the Inspector General to investigate the Hinman speech. Additionally, my Connect to Congress campaign has caused almost 60,000 messages to reach members of Congress regarding the improprieties related to the Hinman speech. Recently, during a congressional hearing, the Director of Enforcement was questioned regarding the speech and the ethical issues associated with giving it. Hence, the SEC's vicious personal attack on me. So think about this. By attacking John Deaton personally, it opened the door for him to explain why the SEC is attacking him, including info about Hinman's Ethereum free pass speech. So this is stuff that otherwise it would have been relevant. The judge would not have been happy if he just brought this stuff up under such circumstances, but now that he's getting attacked, of course he can address it. He's well within his rights to address why the SEC is doing what it's doing. Think about that. And so if not for them being disingenuous little pricks, this information might have never made it to the judge. Think about that. They're shooting themselves in the foot, folks. That's what they're doing. Section 6, titled Conclusion. Amici should not be denied participation. This is the last section. The relevant inquiry is whether this court views an amicus brief, quote, desirable because they represent third parties whose particular interests may be affected by the court's ruling and whose particular interests are echoed in broader public interests, end quote. And the reason that that's in quote is because that came from the court itself. And so John Deaton's just citing that there. Attorney Deaton then continues and writes, in light of the court's language, other than summary judgment, it is difficult to imagine a more specific and relevant issue deserving Amici's participation. It is undeniable that Amici's interests, quote, are echoed in broader public interests, end quote. Although this court envisioned Amici's assistance during briefing on dispositive motions, the court stated it, quote, may exercise its discretion to request or deny further applications as appropriate, end quote. Considering the SEC's unyielding claim that all XRP are investment contracts per se, the court's decision regarding Daubert could prove dispositive. And so, and when it says dispositive, just be clear, meaning that such arguments may impact directly how the lawsuit ends. Well, that's exactly why it's here. And then Attorney Deaton continues. Amici should not be punished for making such an application. The expert's opinion and testimony strike at the heart of Amici's desired role in this case. The only chance the SEC has at establishing today's XRP traded in the secondary market is an investment contract, or representation thereof, is by offering expert testimony regarding the state of mind of secondary market purchasers, like Amici. Amici did not rely on the efforts of Ripple when acquiring XRP, nor will they voluntarily choose to rely on the efforts of Ripple or its defense team to protect them. Accordingly, while Ripple is capable of litigating the Daubert issue, Amici's participation at this stage, and clearly at the dispositive motion stage, will offer the court the unique perspective it recognized as important when it first granted Amici status to XRP holders. Bam! Golf clap for Mr. Deaton, everybody. It's amazing, how do you fit that much information in 4 pages? It's so concise and so powerful. So well done here. So well done. I was lighting up as I was reading this earlier today. I was going through and I was making my notes and highlighting the parts that I found most relevant, which ended up being, as I started going, I was like, oh, it's just going to be like everything. Seriously, you should look at my paper that I'm holding right here. Almost 100% of it is highlighted. I think it's highlighted. It's all highlighted. Yeah, it's all right here. And this is cool too. So there was something that Attorney Jeremy Hogan referenced in this tweet here. I'll pull back up for just a second. He wrote, also happens to spill on Hinman and his relation to Ethereum. What's being referenced right there? The footnote. It's at the bottom of page 4. So Attorney Hogan shared a screen grab of that. And I'll go back to the actual document here, but it's right here at the bottom of page 4 on your screen, which reads as follows. And again, think about this. This would not have been relevant, and Attorney Deaton would not have brought this up if not for the SEC choosing to attack him. So this is, it's coming around to bite him on the rear side so far as I'm concerned, but here's footnote 2. Reads as follows. While at the SEC, Hinman was also a profit-sharing partner at Simpson Thacher, a member of the Enterprise Ethereum Alliance, which exclusively promotes Ether. The SEC ethics chief informed Hinman he was criminally barred from contacting his partners at Simpson Thacher, although he continued to do so. How about that? Is that not relevant? And then in a separate tweet, and I think this is highly relevant for that reason, because clearly there are ethical concerns regarding, the fact that Hinman gave this Ethereum free pass speech, given that it clearly had ramifications for his former employer, Simpson Thacher. And then, of course, as I'm sure most of you know, after he left the SEC, he went back under their employ. Yes, he wasn't retired, my friends. He left Simpson Thacher, worked at the SEC, then when he left the SEC, he went back to Simpson Thacher. And so Attorney Hogan wrote this on Twitter. He said, a judge that becomes aware of criminal activity in a civil case will refer the issue to the relevant prosecutorial office. I've seen it done before. So I don't know for sure if he had that in mind. I'm hazarding a guess that perhaps that is the case. But there's potentially something criminal there. We don't know. I can't say definitively. I don't even have a law background. I'm just saying. Makes you wonder, though. So, wow. Attorney Deaton. Home run, folks. I am looking forward to seeing what the response is. I'd be absolutely blown away if it ended up going well for the SEC. Kicking Deaton out at this point? Are you kidding me? There weren't even new accusations other than you could say someone who wasn't Deaton sent some sort of inappropriate communication about an expert witness. That's not even Attorney Deaton, though. Attorney Deaton's been trying to tamp down, type of emotional responses that they're citing here. So no. Let me know what you all think. But wow, it was just a complete thrill to read this earlier today. Hopefully you guys enjoyed that just as much as I did. But I find it so satisfying, especially when these little I'm going to censor myself a little. When these alleged humans at the SEC, when they were doing things that they actually believe are going to help them, I think that they're making the case worse for them. They're not. This is not going to result in any favors being presented to them by the judge. At least I certainly don't think so. But I'll go ahead and wrap up here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.